Well, good morning. Welcome to Sunday Morning Coffee with Dr. Childress here. Today, I want to discuss the broken legal system and what's happening um, in the family courts surrounding the causes and the solution to the broken legal system in the family courts. Just a second, I'm trying to get my side of the screen all set up. Okay, so relative to the broken family court system. Um, I want to begin by discussing a an actual um, story from the family courts relative to the broken legal system. And this story comes from my involvement with Dorsey Pruder in the Conscious Co-Parenting Institute and her High Road workshop. Now, if you're familiar with my work, you're familiar with this diagram. This is the data from uh, a single case of ABA study of the High Road workshop. And the High Road workshop is 2 days of the High Road. It's the B phase here. And then my therapy is the second A phase. And the first A phase is the involvement of the family courts. It goes back way back in the mental health system as well. And because I was the follow up therapist with this, I was able to read the mental health reports surrounding this family. And because continuity of care was coming into my care. And so I kind of know the history relative to this family. And significantly, there were three mental health involved people over 3 years. All three of the mental health people diagnosed child abuse. And here's some of the direct quotes from their reports that they wrote over 3 years of child abuse. So the first mental health professional wrote, the father displayed in my office the most extreme antagonistic, narcissistic based behavior I have ever seen. The father's full manipulation of the child has completely dominated every area of his life, school, friends, and family. The child lives in constant fear of displeasing his father and has no independent thinking apart from what his father requires. So, this is a mental health report going into the court. Later, another year later, after the court did nothing to protect the child, a second mental health professional writes to the court. It is my belief that child's name is a victim of child psychological abuse from the father. It is my belief that the messages the child has been receiving from the father have resulted in significant psychological harm to the father. The court did nothing. A year later, the third mental health professional informs the court. It is clear to me that child who lives with his dad and gets a few hours per week of visitation with his mother has been mentally and emotionally abused by this father for the past year. So, over the course of 3 years, multiple mental health professionals are telling the court that the father's parenting is psychologically abusive to the child and is destroying the child's life. The court did nothing for 3 years. Finally, it protectively separates the child so that Dorsey can get the child enrolled in her high road workshop. And within 2 days, the child's healthy development with the mother is recovered from 3 years of documented child abuse. I think that's scandalous for the family courts. Judges, the absence of responding from judges to the child abuse in the family courts is just scandalous. But there's a reason for that. I don't necessarily blame the judges fully on this because the mental health people aren't stepping up. But in this case, the mental health people definitely told the court that there was child abuse, and the court did nothing to protect the child, and it is documented into the record. And so you can, if anybody, legislator, anybody will get a hold of Dorsey, she can tell you exactly who the person is protecting confidentiality rights on that situation and the court situation and describe the whole thing. So let's start by talking about what the problem is. There's two broken systems that are involved in the family courts. The legal system is broken, And the legal system is the point of first contact surrounding the custody conflict. However, it's not a violation of the law that's the issue. We're not talking embezzlement or murder or something. We're talking about family pathology, attachment pathology. So the second involved system is the mental health system, which is the primary domain of the problem's identification, diagnosis, and resolution, treatment. And so the problem at its core is a pathology, and the problem at its core needs to be fixed by the mental health system. The legal system is an adjunctive system relative to the pathology. So the fundamentally, the mental health system is broken, and so the source of the source of the legal system's problems is the broken mental health system. The court is not getting the information the court needs to make its decisions. But this is a pathology, and the responsibility for identifying and fixing the pathology is to the mental health system, not to the legal system. And it's the mental health system that's failing. The broken mental health system is not providing the courts with the necessary information needed for the court to make its decisions. And while the source of the is the broken mental health system, not diagnosing or informing the court or fulfilling our obligations, the legal system is also separately broken. But we can't fix the broken legal system until we fix the broken mental health system because the court system, the legal system, has adapted itself to the absence of competent mental health services. So I'll discuss that later. But within the court system, there's several areas that need to be addressed, need to be sort of conscious awareness and some self reflective insight and discussion within the legal profession with some mental health input about how they're going to handle certain issues. One is a zealous advocate role for attorneys is not appropriate for family court conflict involving possible child abuse. Attorneys are officers of the court. They should not be using their legal knowledge to participate in child abuse and spousal abuse and to manipulate the court or manipulate the legal system to in the support of or in the furtherance of child abuse and spousal abuse. And because these are abuse diagnoses, that whole zealous advocate role needs to be reconsidered. Now, the where I first was heard that was I was invited to speak to the Saskatchewan Law Society. And so I went up there to give a talk. And in the afternoon, there was a panel discussion I participated in. And one of the attorneys on the panel discussion made exactly this point about the zealous advocate role not being appropriate. And I thought it was an excellent presentation and spot on in the analysis that the zealous advocate role is not appropriate for attorneys in family court situations involving possible child abuse. So the court and the legal system needs to address that issue. And there's ways to address it. We know what the pathology is coming in, and we can kind of work collaboratively to make sure that the child abuse concerns get properly addressed. And so the other problem in the family courts is that there's no planning or preparation. The family courts act like each one of these cases is unique. No, the cases are a pattern. They're a type of pathology. So we can plan for them and we can prepare for them, but that hasn't taken place. One of the reasons that hasn't taken place is because we've never had an established diagnosis of what the pathology is. Once we establish what it is in actual clinical psychology terms, then we're able to plan for it and prepare for it. So the failure in planning and preparation is actually one of those adaptations to the failed mental health system. The moment the courts start getting the appropriate information, they can start planning and preparing for the pathology that's coming. Then, when doctors don't diagnose, judges must become doctors. So the judges have also adapted by having to diagnose the pathology in the family courts. Doctors don't diagnose pathology. They went to law school. They didn't go to psychology school. So it's the broken mental health system is placing burdens, unnecessary and burdens and inappropriate burdens on the judges and the family court system. So everyone needs to, everyone in the family courts is out of their proper role within their systems. And it starts with the forensic psychologists. They try to become mini judges and start deciding on custody rather than doing their job of diagnosis and treatment. So there's no diagnosis and treatment, which means the court now needs to come over and do the healthcare job. Everybody needs to get back in their lanes, and we need to get rid of forensic psychology entirely. Um, Custody is a false focus, and this is important to understand that this isn't about custody. Custody is simple. It's 50-50 or every other weekend. The issue that's adding complexity to the situation is the conflict that's surrounding the child's attachment pathology, and then the corresponding concerns for child safety that the child's symptoms and allegations surrounding the family create. And so this represents the focus on the custody rather than the pathology represents a manipulation of the courts by a narcissistic borderline dark personality parent. They're getting everybody to believe this is about custody and everybody's focusing on custody. No, it's not. That's manipulating the system because the legal system is very structured. So the narcissistic borderline uh, dark personality is just able to play it like a piano. They know what the structures is. They come in with a false pathology that creates safety concerns, and they just trigger the mental health system to do, or trigger the legal system to then do what it does. So the first thing for everybody to recognize is that high conflict surrounding child custody is not normal. That research, Cini and Birnbaum, that Hetherington, Stanley, Hagen, and Anderson note that 90% of custody matters are settled before the parents even reach the courts. 90% of custody is settled. You know why? Because 90% of parents have normal range empathy for their child, and they won't put their child through a high cost custody conflict. So if we have custody conflicts surrounding these divorces in 10% of the cases, why is that? Well, it's because of the pathological parents are high conflict. So from Horan, Gwynn, and Banghart, consistent with calls from prior research, the aim of this study was to understand how reports of the dark triad, subclinical narcissism, subclinical psychopathy, and Machiavellianism, related to conflict communication in romantic relationships. Results indicated that individuals reporting higher levels of dark triad personality structure are also reported more frequent disagreement that was also intense and hostile. So this goes back to the issue of planning and preparation. We know that high conflict is not normal. 90% that's not normal. So we know we have pathology. Just simply the fact that we got the high conflict situation, there's pathology creating the high conflict. So what's the pathology of high conflict? Personality pathology. And we know dark triads are going to create the high conflict situation. So we should be preparing in the family courts for this type of personality, this high conflict, dark personality, to be present. So, moreover, dark triad personality reports were directly related to the use of contempt, criticism, stonewalling, and defensiveness messages collectively known as the four horsemen as they predict relational termination. So, you see the article, dark triad and conflict communication. So, we've identified even the type of high conflict communication that they are making that led to the divorce, the relational termination, and is now leading to the custody conflict following the divorce. This is not something new. We know what the pathology is. We're just not addressing it. And that's the problem with the forensic psychologists. They are just awful. And they have not been providing the court with the information the court needs. So the dark triad manipulation of the courts. What's the dark triad? First cited by Paulhus and Williams, the dark triad refers to a set of three distinct but related antisocial personality traits. Machiavellianism, they are highly manipulative. And they're manipulating the courts. They're manipulating this to everybody believing this is a custody conflict when actually it's pathology and needs a diagnosis and treatment. Narcissism, absence of empathy. That's what gets you into the high conflict divorce. They have no empathy for the child. And so they put the child in the middle of the divorce to get their own needs met. And psychopathy. They're psychopathic. So again, that's highly manipulative, no sense of morality, no sense of right and wrong, and just they're out to meet their own needs. Each of the dark triad traits is associated with feelings of superiority and privilege. This, coupled with a lack of remorse and empathy, often leads individuals high in these socially malevolent traits to exploit others for their own personal gain. They are exploiting the child and the child's induced pathology relative to the other parent for their own personal gain. That's the pathology in the family courts. You have a narcissistic, borderline dark personality pathology who's creating a persecutory delusion in the child, shared induced persecutory delusion, and false, factitious attachment pathology to meet their own needs. We need to plan for it. We need to prepare for it. This is not normal. Normal doesn't do this to their children. Another citation, Donner, 2006. As many as half of all marriages end in divorce, and 90% of parents make their own custody arrangements. Fewer than 4% of custody disputes result in litigation. This is not normal. Just simply, if once the court makes its decisions about what custody is around the divorce, that shouldn't even be happening. In the initial divorce event, the parents should make their own custody kind of arrangements, but sometimes the court may need to get involved. Divorce can get a little intense, and so the court may need to establish initial custody. But once the court establishes custody, all normal range people can need to cope with that. No normal range parent drives this into a custody conflict. And so if you've got a custody conflict coming into the courts, suspect personality pathology, one parent or the other. Now, the personality pathology could be with the targeted parent who's abusing the child. And so it could be an authentic child abuse situation, but that's going to be the narcissistic dark personality who's abusing the child. Or we have false allegations and we got the manipulation of the court. But expect it, know what the pathology is, and expect it. Expect it in the family courts. The custody focus is a symptom. It's not the primary issue. And everybody's getting wrapped up in a symptom. It's a symptom of manipulation. It's a symptom of child abuse and spousal abuse. The focus should be on treatment. How do we fix the pathology? This is a pathology. The focus should not be on custody. A custody conflict is a manipulated focus by a dark personality, narcissistic, borderline dark personality. The pathological parent drives this into the court system for a variety of reasons. And the reason they drive it in the court system, or how they do that, is by creating disruptions to the conflict, to the custody. So as soon as they get the custody in play, then it goes into the court system and they can manipulate the court system to get what they want. The pathological parent disrupts custody by creating and then exploiting, exploitation, narcissistic, by creating, then exploiting the child's induced attachment pathology and the safety concerns that surround that, either overt, they make allegations of abuse overtly, or implied by the child's symptoms. If the child's rejecting a parent, they put the child out front and say, and imply that somehow that the targeted parent's parenting is abusive of the child by implication. But one way or the other, they trigger the court into the safety issues. So the courts are being used, manipulated, Machiavellian levels of manipulation. If you want to know why the Machiavellian manipulation, this is an example of it. How the narcissistic, borderline dark personality parent is just playing the legal system. They're just manipulating the courts and all things because it's so structured. They know how it's going to respond, so they just make it respond the way they want it to. So they manipulate the courts by triggering the court's response to the false safety concerns from allegations, either overt or implied, of possible abuse somehow. And they use that to achieve a court ordered protective separation from the targeted parent, because the moment there's allegations of abuse, the court goes, "Whoa, wait a minute, let's get a separation here." So they give custody over to the parent, the pathological parent, and maybe if they're really good at the manipulation, they can get the targeted parent placed on supervision during the investigation phase. So during that investigation, they obtain full custody of the child. And then they exploit delays that are inherent to the legal system. Oh my gosh, the legal system is full of delays. They put off hearings for 3 months, 2 months, 6 years, 6 months. And so there's ways that attorneys for the pathological parent can manipulate that and continue to get delays and fight about everything. And so the pathological parent then exploits those delays inherent to the legal system to maintain the status quo of 100% custody to the pathological parent, potentially supervision of the targeted parent, which allows them the power then to then create the pathology. And this is an important feature relative to the child, is the power dynamic that's being manipulated in this situation. By disempowering the targeted parent entirely in their ability to protect the child's now over 100% with the pathological parent. That targeted parent cannot protect the child. And that's evident to the child. The child is this parent that I'm with now is the powerful one. They've totally disempowered the other parent. I can't even see the other parent. This one is the one I have to deal with. So I'm going to have to do whatever I have to do to deal with this powerful parent. And so it's all part of the domination and control and manipulation of the child. And then when they get the child on sole custody for 6 months to a year following the divorce because of these allegations, either overt or implied, then they have a year to create this alliance in the child and the false belief systems and everything. And with no mental health involvement, with no balancing input from the other parent. So it is highly manipulative of the court system. The fundamental feature that's driving all of this is a spousal abuse goal. The narcissistic borderline dark personality parent is exploiting the legal system and custody conflict as a weapon of emotional, psychological, and financial spousal abuse of the targeted parent with the aid of attorneys and the court. And that's what the legal system needs to self-reflect on and consider, is they are being manipulated with the participation of at least one attorney. So the attorney for the pathological abusive parent is participating in the goal of the spousal abuse of the other parent using the child as a weapon. That's highly problematic. Okay, for an attorney, an officer of the court to be a spousal abuser and participating in the spousal abuse is ethically problematic for attorneys. So that needs to be looked at. And when the attorneys convince the court to protect the child falsely or use delays with the court and manipulate, when the attorneys use their attorney knowledge to manipulate the court to support their abusive clients, spousal abuse of the other parent, the court becomes a participant in the spousal abuse. And that's what the judges and the court need to more fully examine relative to their role, is that when you get concerns about child protection, allegations either overt or implied, the court naturally is going to protect the child, and that's fine. Okay, so you do the protective separation, you move the custody over to the more vulnerable parent or the allied parent during the investigation. But in the back of your mind, you should know that if this comes back negative and there's no child protection concerns, then you have just participated in creating false attachment pathology in the child. So you have participated in this child's psychological abuse, the court has, by communicating to the child that the judge, the court believes the targeted parent presents a danger. That's why you separated. And so you've communicated to the child that the other parent is a danger to the child. That's false narrative. So if you go back and then correct that legally and say there's no danger and you restore contact, you also must take steps to correct the spousal abuse and the child abuse that you were manipulated into participating in. And so you're going to have to recognize that if we go the other direction and identify the pathological parent as the allied parent, then we need to take active steps to correct what happened, the prior manipulation of the court. Um, the motivations here, is using exploiting the legal system as a weapon of spousal abuse with the aid of attorneys and courts. And what they're seeking to do is to put the targeted parent on trial for being a bad parent, actually being a bad spouse. And so it's part of their primitive pathology. They got a divorce and they have animosity and anger towards the previous ex. So they're going to put them on trial and make them defend that they deserve to be a parent, and they can bring up all the past spousal abuse things and oh, they mistreated me and I know exactly how the child feels and all this kind of stuff. So that's part of the goal, is to put the targeted parent on trial for being a bad spouse, a bad parent. Um, they seek to publicly shame the targeted parent with allegations made in a public setting. So all these declarations, all this custody conflict in the courts, they're able to submit legal documents that make all these slanderous allegations and personal allegations and just publicly shame the the targeted parent, or at least they try to. And then the third motivation is they seek to make it as hard as possible for the targeted parent to see their child. The court delays make it really hard. To prove that you didn't abuse the child or that you're a normal range parent, you have to prove it in a legal system, a trial in court. The whole manipulation of driving it into the legal system is to make it as hard as possible to see the child. And this isn't a custody issue, it's a pathology issue. It needs to move over into the mental health system, not the legal system. So that's part of the recommendations I'll be making, is get it out to the mental health system as fast as possible. Now, given or and I can talk more about this later in future and stuff, but given that this is a false pathology and the courts are being manipulated and the whole issue of child custody is a false issue, it's a symptom of the personality pathology and the absence of empathy. It should be in the mental health system. Instead, in a normal range parent after divorce, if they're concerned about the other parent's parenting, they're going to move it into treatment. They're going to move it over to the mental health people and get treatment providers. I've worked with those families where a mom and dad, after the divorce, mom is worried about dad's harsh parenting. And so they come to me to help with the situation. Maybe the child's got some behavior problems at school or something that triggers things in. And as I explored, it's mom's concerned about the other parent. However, with normal parents, with normal moms, she actually wants a restoration with that parent. And so she brings it into me for therapy to do that. And I tried my best and I do my best to get that in place. And so that's a normal range parent doesn't move it into custody. They move it into treatment. Okay. If it's in custody, and especially if you have either parent asking for sole custody on this, that should be a red flag for you. Um, even the targeted parent, that's a protective separation period of about 3 months if there's child psychological abuse by the allied parent. So you get a period of protective separation, but the goal is 50-50 or shared parenting. That's always the goal. And we limit the amount of separation because that's inducing attachment pathology. So the inducing attachment pathology is never a treatment for attachment pathology. It's an intervention, a safety plan for child protection concerns. But the reason we need that protective separation on psychological child abuse by the allied parent is because if we're trying to restore the child's healthy bond to the targeted parent, and the pathological parent is trying to keep the child symptomatic, we're going to just wind up ripping the child apart between the motivations of therapy to restore the child bond to the healthy parent and the motivations of the allied parent to keep the child symptomatic. So in order for treatment, we have to provide a brief period when we eliminate the distorting influence of the pathological parent. We can recover the bonds without ripping the child apart, and then we restore with the formerly abusive parent or with the abusive parent, with enough safeguards in place to make sure the child abuse doesn't resume once contact is restored. So diagnosis guides treatment. That's why we need a child abuse diagnosis one way or the other. So we know, are we protecting the child from the targeted parent, or are we protecting the child from the allied parent? And that's a critical treatment decision. And that's a critical decision that the court needs to understand. That the court needs to be getting mental health information about which parent is abusing the child, and then the court can make a decision as to its child protection obligations. But if it's not getting that information from mental health, then the court has like up in the air and has to decide and start making diagnoses of child abuse, and that's not the court's role, and that's not their training or background, and so everybody gets out of their role when the mental health people stop doing their job. So the pathology is, and this is important for the court to understand because they've been lulled to sleep by the forensic psychologists by not diagnosing the pathology and not communicating that to the court. This is the pathology, Your Honor. This is the what we're concerned about. It is a DSM diagnosis of child psychological abuse, pathogenic parenting by the allied parent that's producing pathology in the child for secondary gain to the parent. Type of pathology is persecutory delusion and factitious attachment pathology. And we are concerned about spouse or partner abuse psychological using the child as a weapon. So we have two abuse diagnoses of concern, Your Honor, and both of those warrant a proper assessment and protection concerns. And so I know everybody says, this isn't about the parent, it's about the child. And I totally get that. Totally. And at the same time, as a professional, I realize that there's also a second level of abuse, of the spousal abuse, that as a professional, we also need to address. So we have multiple abuse concerns in the family courts. And to emphasize the nature of how severe the pathology is, everybody looks at the pathological allied parent enmeshed kind of thing and says, "Oh, that's the child's bonded to the allied parent." No, the child's not bonded to the allied parent. That's a pathological relationship of enmeshment. It's called a boundary dissolution. Let me point out some of the symptoms you're going to be seeing. That the child, that the allied parent is grooming the child before the divorce, even, but soon after the divorce, definitely. They start grooming the child into forming a special relationship of shared affection that excludes the other parent. They then seduce the child into a cross generational coalition against the other parent and it's in a situation where the allied parent has complete power. They have full custody given by the court around these safety concerns, and there's no hope of rescue for the child. So the child is over with the pathological parent with no hope of rescue because that parent has clearly demonstrated to the child they are powerful and the targeted parent is not. And so the targeted parent cannot protect the child. And so the child has to do what the parent wants them to do. and it involves the psychological control and manipulation of the child to meet the emotional and psychological needs of the parent. Now, when you look at that list of characteristics and features, I want to just emphasize, does that remind you of something? This is not, this is a ripple. It's called the transgenerational transmission of trauma. This is, trauma. Let me explain something about trauma for a second. Trauma is like a rock that you throw into a lake. So there's the rock of the abuse, there's the splash of the trauma, and then there's the ripples that go out. And what we're in right now in the family courts is not the rock or the splash. That's authentic child abuse. And there could be some cases of authentic child abuse, but mostly those wind up in, you know, different settings. Those go into CPS and get allegations of child abuse confirmed, and a different approach to real authentic child abuse, the rock and the splash. What we have in the family courts is a prior rock and splash generations before that is now rippling. And so we see the symptom features of the ripple, but it's not the actual trauma in the situation. That's transgenerational trauma. It's the ripple, not the rock. So there are 4 diagnoses of child abuse in the DSM-5: physical, sexual neglect, and psychological child abuse. All of them are equally damaging to the child. They differ only in the type of damage done, not in the severity of the damage done. And psychological abuse is devastating because it destroys the child from the inside out. And if, from my perspective as a clinical psychologist, if we don't get a handle on stopping the child psychological abuse, it becomes highly treatment resistant to untreatable in adulthood, because the child, as they're developing, they have a point at this custody when the family gets a divorce where they can go 2 different directions. If we protect them from the child abuse, psychological abuse by the allied parent, they're going to have normal, healthy attachment bonds, um, as healthy as we can get them with a pathological parent, but they're going to have normal range attachment bonds, and that will lead to a normal range life of family and jobs and life. If, however, we don't protect the child from the psychological child abuse, then their attachment systems are going to be devastated, and all the relationships and all decision making and emotions are going to be problematic. Uh, Affect regulation is going to be problematic, and their life course is going to take an entirely different course, a more destructive course. And so we have a bifurcation point right now. The court's decision is going to put the child on a path of healthy or a path of destruction. And if we put the child on a path of destruction, then can we recover the child when they're 20 or 30? Yeah. We can get the child out of the delusion, or the now adult out of the delusional disorder, and restore with an adult to an adult parent child. But all the damage has already been done. That life courses, and so I can't fix all the damage that was caused by untreated psychological child abuse. So right now, as we have the divorce, let's treat the child abuse issues and let's fix the family pathology so we can get this child on a um, normal range childhood. So fundamentally, this is important to understand. Forensic psychology failed to identify for the court the severity and nature of the pathology involved. It's child abuse. Forensic psychology did a very bad thing. They experimented on these families. They made up a new approach to service delivery. It completely failed. Thousands of lives were destroyed, of children and parents, by the failure of forensic psychology in their experimental new approach. If they get credit for success, I think they should get responsibility as well for their failure and the consequences of their failure. What they did was unethical across multiple ethical standards, and it resulted in widespread damage. And there are specific people. So if you look at Tervita and you say 30 years of working in the family courts, that's one of them. They've been doing this for 30 years of failing to provide the court with information, failing to protect children. So they did a very bad thing. Forensic psychology, one of the bad things they did was they lulled the legal system to sleep in their response so that the legal system has no urgency to it. There is urgency. This is child abuse, this is spousal abuse, and we need to up our attention to the nature of the situation. First off, forensic psychology needs to end. Clinical psychology needs to return, diagnosis and treatment. However, clinical psychologists will refuse to come work in the family courts because it's too professionally dangerous to their license. That's what I am partially exposing over here, that it's dangerous to clinical psychologists to work in the family courts. Even me, and I'm saying everybody needs to be ethical, everybody needs to do the right thing, and it's dangerous to me because the forensic psychologists control the licensing boards. Okay, that's fundamentally it. All clinical psychologists know this. That's why we won't come here, because we'll get sanctioned just simply because we're not forensic psychologists and there's nothing we can do about it. That's what I've exposed, that the licensing boards are corrupt with the influence of the forensic psychologists. We need state legislatures, we need the APA over here, we need people looking at the licensing boards. Why have the licensing boards failed in their obligation to get parents competent mental health services? If I'm banging on the forensic psychologist for being ignorant like a rock and for failing in multiple ethical standards, who's responsible for maintaining ethical standards? Who's responsible for protecting the consumers from unethical, incompetent malpractice? The licensing boards. Well, guess what? They've failed massively. Why? Is it because they're bad people? No, it's because their forensic psychologists are in the licensing boards and they are disabling the response of the licensing boards to the pathology. The forensic psychologists are in the APA. They're disabling the APA response to the pathology. And so getting rid of the forensic psychologist is one of the best things the family court system can do. But then we need to get the clinical psychologists back and they won't come. So we need to address that issue as well. This is child abuse. There is urgency in the situation. So what do we do for our solutions, our starting solutions? First off, everybody needs to get back in our lanes. Okay, we got all messed up because of these forensic psychologists and their new experimental approach. No, let's end the experimental approach. It failed. Let's get back to the clinical psychology. So doctors need to return to being doctors. Doctors diagnose and treat pathology. We don't have opinions on child custody. In the absence of child abuse, parents have the right to parent according to their cultural values, personal values, and religious values. In the absence of child abuse, each parent should have as much time and involvement with the child as possible. And in the absence of child abuse, to restrict either parent's time and involvement with the child would damage that child's attachment bond to that parent, thereby harming the child and harming that parent. So the only question for doctors is there child abuse? And that's the fundamental question we need to be answering. We need to get out of the custody situation. That's custody decisions are the court's decision. The question for doctors is what is the diagnosis and treatment plan? We should be giving the courts treatment plans, written treatment plans that fix things. Judges need to return to being judges. They have compensated for the absence of mental health information. So they don't know what to do. They keep reaching out to psychology for input, but they keep getting awful, awful input that doesn't solve anything. So they have expanded their role into having to diagnose the pathology, identify the pathology. And that's not the role of judges. Judges went to law school. They didn't go to psychology school. I don't make rulings on the law. They shouldn't be making diagnoses. So judges, but fundamentally, though, judges need to be receiving diagnoses from the doctors that are accurate and that the courts can rely on. And the way we get those done is by applying knowledge, and the knowledge, the courts can be familiar with cross-generational coalitions and delusional disorders. They can tell whether or not the knowledge is applied once we educate the courts as to the pathology. But also second opinion. The appellate system for disputed diagnosis in healthcare is second opinion, just like in the legal system. You get another opinion by a appellate judge. In healthcare, same thing. You get a second opinion from another doctor, or even a third opinion. So and since we know this is going to be a disputed diagnosis in the legal system, one party or the other is going to dispute it. So rather than get the second opinion sequentially, and so you get an assessment, you get a diagnosis, then that's challenged, and you get another assessment, another diagnosis, and everybody starts get them simultaneously. So right up front, I'm sitting there talking to you, everybody. Telehealth, we can be in the offices, we can be consulting with other people around. So the doctors need to be doing a lot more case consultation, a lot more consultation, so that we return to the court a second opinion on all these diagnoses, maybe even a third opinion. If you want to go formal, you have one who's doing the diagnostic assessment, then you have two consultants, one appointed by each party. There's your three judge or three doctor appellate panel. And we'll get the court a wonderful report off of a three doctor assessment and diagnosis. It only needs two, really, though. And so, but it should have two. If you just go on one, they're going to be fighting all the time. This is going to be appealed. Get two. So that's how you get the courts a diagnosis that's accurate and one that the court can rely on. We cannot blame the court for any problems the court generates until we first get the court the necessary information it needs for its decision. If we're not getting the court the necessary information, then they're making bad decisions, but it's not their fault. It's the mental health people. And so we have not been getting the court the proper information. So that's fundamentally the problem. We first have to fix the mental health system response, and then we can use the fixed mental health system to fix the problems in the legal system. Forensic psychology has failed the child, it's failed the court, and failed the parents. And so it is time for forensic psychology and their failed experiment to end, and we need to take a different approach. A new approach? No, an old approach. We need to go back to clinical psychology. Okay, that clinical psychology, it's a new approach in the family courts, but it's an old approach going back as far as medicine. Diagnosis guides treatment. We need to return to the established practices of professional psychology and healthcare, and this is a pathology, and we need to fix the pathology. This is not a custody conflict. That's a false focus. So just bringing up the New York Blue Ribbon Commission and the failure of forensic psychology, we need an outside independent review. I would suggest legislatures. I would suggest the APA, the moment they get active in protecting people and their obligations. But here's what an independent outside review found about forensic psychologists. Ultimately, the commission members agreed that some New York judges order forensic evaluations too frequently and often place undue reliance upon them. Judges order forensic evaluations to provide relevant information regarding the best interests of children, and some go far beyond the assessment of whether either party has a mental health condition that has affected their parental behavior. We need to go back to identifying whether either party has a mental health condition affecting their parenting, like a shared persecutory delusion and factitious attachment pathology, narcissistic borderline dark personality type stuff. In their analysis, evaluators may rely on principles and methodologies of dubious validity, in some cases because of lack of evidence or the inability of parties to pay for expensive challenges of an evaluation, defective reports that can thus escape meaningful scrutiny and are often accepted by the court with potentially disastrous consequences for parents and children. Independent review, this is what they're finding. Forensic psychology, defective reports, dubious validity, potentially disastrous consequences. By an 11-9 margin, the majority of commission members favored elimination of forensic custody evaluations entirely. But if we do that, you have no mental health input into the courts regarding pathology. So we need to get clinical psychology back, but they won't come because it's too dangerous. You see the problems we're looking at. The elimination of custody evaluations entirely, arguing that these reports are biased, harmful to children, and lack scientific and legal value. They're worthless, worthless. And I believe the courts understand that after 40 years. That's why the judges are trying to diagnose pathology. That's why the system is broken. And I think everybody kind of realizes the mental health people don't know what they're doing. At worst, evaluations can be dangerous, particularly in situations of domestic violence and child abuse. Holy cow, let's get rid of these things. Let's get clinical psychology back. These members reached the conclusion that the practice is beyond reform. So everybody's talking about judicial education and everything. Well, first thing, let's get rid of the forensic custody evaluators because the practice is beyond reform. And then we can bring in some education about clinical psychology and how we address it from a healthcare perspective. And that no amount of training for the courts, forensic evaluators, and or court personnel will successfully fix the bias, inequity, and conflict of interest issues that exist within the system. The forensic psychologists do not want to solve the pathology because the moment it's solved by clinical treatment, their career vanishes. I've been working in the family courts for 20 years doing custody evaluations. Well, guess what? We're not doing custody evaluations anymore. Go work with ADHD or something. Your entire 20, they don't want that. That's how they make their car payment, their house payment. That's the conflict of interest issues. You put the fox in charge of the hen house. These mental health people and the forensic psychologists, they have their experimental custody evaluation approach. Have they informed the court and the public that there's an alternative, a clinical diagnostic assessment? No, they haven't. So they haven't informed the court and the public that they don't have to get a forensic evaluation. They can get a clinical diagnostic assessment. Well, why wouldn't they inform them of that? Because then the court and the public will get a clinical diagnostic assessment and stop getting their $20,000 to $40,000 custody evaluation. Conflict of interest is huge in the family courts regarding forensic psychology. So we need to get rid of them. So my recommendations, regarding the legal system response to custody conflict. First, diagnosis. We need to obtain an accurate diagnosis and written treatment plan with outcome measures, all cases. And the courts need to accept the diagnosis made by the mental health system. And at the same time, the mental health system has obligations and it has failed. The mental health system must end its failure. So the court must rely on the diagnosis received from mental health, and the mental health people have to step up and make sure we're giving the court an accurate diagnosis it can rely on. And we fix the mental health system, then we can fix the legal system. But if the legal system doesn't trust the mental health people, then everything's broken. I strongly recommend that the legal system review and revise the zealous advocate role for attorneys. It is not appropriate for child abuse issues. I suggest that minors counsel be eliminated as a role relative to custody conflicts. They are extraordinarily destructive. If you appoint a minors counsel, from my opinion, as a clinical psychologist doctor, you have just appointed an attorney to represent the pathology. And so you might as well appoint an attorney to represent treatment. Then we'll have 4 attorneys, one for each party and one for the pathology and one for the treatment. The mental health, the minors counsel are not trained, they're lawyers, they're not trained in pathology. If you believe the shared delusion, you become part of the shared delusion, you become part of the child abuse. They believe the shared delusion because that's their role as minors counsel. They express voice of the child, so they become a representative for the child abuse. And so that whole zealous advocate and roles of attorneys needs, I recommend an amicus attorney. That came from a recommendation of an attorney in Texas many years ago. And that's the role that's needed is an attorney who represents the interests of the court in the child's treatment. Okay, that's your amicus attorney, then, and they'd be part of the treatment team surrounding the child. So it'd be an attorney representing the interest of the court in the child's successful treatment. They'd monitor the treatment plan. They'd interface with the court on any sort of treatment related issues. And then we have to make it safe for the doctors. We need a standardized and agreed upon diagnostic assessment protocol and a pilot program for the family courts with university involvement. Will provide that. I've provided that. Okay, so you can go to my diagnostic checklist and parenting practices rating scale, outcome measure of the parent-child relationship rating scale. So I've provided you with all this information. But if you're going to fight about me, well, then do it yourself. Get a pilot program for the family courts with university involvement to come up with a standardized diagnostic assessment and treatment protocols for the pathology in the family courts, shared persecutory delusion, factitious disorders, child abuse, personality pathology. So you can do that. Universities can do that if you task them with. They're going to need funding for it. Get the state legislatures to fund a pilot program for the family courts, come up with the solution. But the clinical psychologists will not return if you put their license at risk. They shouldn't have to. I shouldn't have to put my license at risk to help families. That should not happen. But that does happen in the family courts. So if you threaten the doctors, you threaten the licensed doctors, they won't come, which is what the pathology does. You see, it's manipulation. It threatens the doctors. The doctors don't show up, and then the courts have no mental health competence, and the targeted parent has no mental health competence. Consultation resources. I have provided so much to everybody. So there's YouTube seminars and presentations. I've talked about all the different aspects. I've explained it multiple times what the pathology is. So you have multiple YouTube resources available. I have handouts available on my website, with all the descriptions and risk assessments and description of the pathology and everything. I have booklets, lots of booklets that I produced. Narcissistic Parent describes the narcissistic parent and the pathology that they create in the family courts. A little short booklet. Judges, attorneys, GALs, everybody take a look and see what we're dealing with here. I provided a booklet on the the assessment of attachment related pathology surrounding divorce. So if you want to know how to assess, I got a booklet for you on this. I've got a booklet on contingent visitation schedule. So a structured treatment intervention for the family courts. You raise and lower the child's custody contact with the abusive parent based on the child's symptoms. When the child's symptoms go up, you reduce contact. Child symptoms go down, normal range, then you go back to your normal custody schedule. That takes the motivation away from the allied parent to produce pathology because it's no longer working. Instead of getting the child 100% custody when you make false allegations, you actually get less child time when you start making false allegations. And instead of labeling the targeted parent as abusive, you get labeled as abuse. It's not, the manipulations aren't working anymore. So the pathological parent stops producing the pathology in the child because it's not working. That's called functional behavioral analysis. You make the symptom ineffective, inefficient, or irrelevant. Do you know functional family system or functional behavioral analysis? No, you don't. You don't even know applied behavioral analysis. The level of knowledge in the family courts is phenomenally low. So you have lots of resources, and those resources are available to everybody. They're available to attorneys and judges and GALs, and everybody can look at the online stuff that's available. Plus, I hold general public consultations the first week of every month in my online office at Doxy Me, Dr. Childress. and scheduling is through my consulting website. So any GAL, parenting coordinator, judge, attorney, mental health professional, parent, reporter, anybody who wants to talk with me can go to my website, schedule on a consult first week of any month. Okay. And I'll talk to anybody. And that's the thing. I'll talk to anybody once to find out what they want to talk about. I don't know who you are. What do you want to talk about? And I have an online office. We have the internet. We can do that. Schedule an appointment. We can talk. So I'll talk to the general public. I'll talk to mental health professionals. I'll talk to legal professionals. I'll talk to legislators. I'll talk to reporters. I'll talk to Martians, the first week of every month to find out what they want to talk about. And so the resources are available if there's a motivation to solve the pathology. Right now, there's no motivation. But it's easy peasy, if I don't need to know it's a judge, just schedule up and just talk to me and say, I work in the legal system. I'm an attorney and you want to talk about the pathology, we can talk about it. I don't know who you are or what you do. And so I'm available for consultation, easy peasy. And then I would also recommend that we get debates and discussions online so everybody can hear and we educate everybody about what the pathology is and what to do about it. I recommend that the legal profession and law schools host online debates and panel discussions on the issues needing professional attention, discussion, and resolution. Right off the top, I'd say a debate on the role of forensic and clinical psychology in the family courts. I'll represent for clinical psychology, find somebody to represent for forensic psychology, and let's have an online debate regarding our respective roles. How about a panel discussion on finding solutions for high conflict custody litigation? I'll participate in the panel. I'll offer up some solutions. You get some other people on the panel, offer up their solutions, and we can have an educated professional discussion about what we do. How about some seminars? You look at the seminar I'm doing right now. I can do these seminars, piece of cake anytime. And I am. I'm putting them up on the web so you have seminars. But if the legal profession, if somebody wants a seminar on, let's say, the diagnostic assessment of attachment pathology in the family courts, how about the licensing boards having a seminar on professional competence in the family courts? You want Dr. Childress to present a seminar on competence in the family courts for the licensing boards? Easy peasy, invite me to do that. So as soon as there's the motivation to solve the pathology is solvable. The problem is there's just no motivation right now. So the important thing for the court to understand is that there's allegations by two parents, both litigants. And the allegations by the allied parent and child is that there's child abuse in some way by the targeted parent, either physical, sexual, neglect, or psychological. And the allegations by the other litigant, the targeted parent, is that there's child psychological abuse by the allied parent, a shared persecutory delusion, factitious attachment pathology imposed on the child. So in all cases of court-involved custody conflict involving severe attachment pathology displayed by the child, a child rejecting a parent, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnosis for each parent. That would be the very first thing we need to start doing. Why are you making these parents have to go through all this litigation to get a risk assessment for their child? It should be routine. If you've got two parents both making allegations of child abuse relative to the other, let's get a risk assessment for that possibility to the differential. And we should just be structuring that in so that pro se parents don't have to fight for it, that the term we get reduce the legal fees and court costs and everything of people trying to get an assessment for what the pathology is. You're being manipulated in the family courts by driving this into the court system, and you're trying to pop it back out to the mental health system, get an assessment, diagnosis, and a treatment plan, then move that back into evidence and move towards a solution. But we need to be preparing and planning for this and not dealing like every case is a unique case. So with that, I'm going to wrap up my Sunday morning coffee this time around, and we'll see what I wind up talking about next week. So take care, everybody, and good luck.